Very good evening, my dear friends. Welcome. Today we are going to discuss about the concept of majority rule under the Companies Act. We have studied in the last session about the meetings of the company. What it tells you, the corporate entity runs its affairs through the decisions taken by the shareholders. I told you, shareholders' body, directors, the staff, and so on. This is how the corporate structure is designed. In that event, the corporate governance is in the hands of the directors. Then the decisions are taken by the directors. However, there are certain decisions which can be taken independently by the directors. There are certain decisions which have to be taken by the directors with the approval of the general body only. And in the event there is a stalemate, it is the general body which will take care and then take over and then pass appropriate resolutions, change the guard if necessary, and then take the reins into their hands, ultimately to reach the goals as laid in the Memorandum of Association of the company. So friends, what it tells you is that it is a majority rule which prevails on corporate governance. And then the decisions are taken through the majority of the shareholders of the company. Company has no physical body. The company has to act necessarily only through the body of shareholders. And then the body of the shareholders ultimately will rule. And then they do and undo things. They have to act in accordance with the objects clause of Memorandum of Association. They have to act in consonance with the provisions of the Companies Act, and then the Memorandum and Articles of Association, the various regulations thereon, the Articles of Association, as I already told you, then various other subsidiary legislations, which are corporate legislations like SEBI, SECRA, depositories, and so on and so forth. Majorly, it is the Companies Act which governs, followed by the Memorandum and Articles of Association. Which means that the majority of the shareholders will have to take appropriate decisions. And then, once in a properly, duly conducted meeting with proper length of notice, I have already explained, a legally valid meeting, the majority takes a decision which is in consonance with the law thereon. It is binding on the company, even on the minority shareholders. Here, minority shareholders means that it is the shareholders which are, in fact, against the majority, and they may be dissenting shareholders. That is how the concept goes on. So friends, prima facie what you have to understand here is that the majority rule prevails on all decisions of the corporate entity, and they play a major role in corporate governance. This is the most important aspect you have to understand, and based on this, you have to proceed further. In the event there is a dissidence, the corporate entity feels aggrieved, then the aggrieved party is none other than the corporate entity itself. Then the company has to then, under the earlier English law, American law, resort to a derivative action, a civil suit against the actions of the directors. But if the majority in a duly conducted meeting upholds any such act and it is within the parameters of the law, then that majority rule is valid and binding and prevailing on all the minority shareholders, so that here minority shareholders cannot have any say. Taking this analogy, we had to study the most important subject matter, which was decided by the English court in F.C.S versus Arbitrator, where the principle laid was that it is a case of judicial non-interference with the activities of the corporate entity, and every member holds equal rights with other members in the same class. And if a person differs with the majority, persons, then the majority acts properly, then it is binding on the minority. If any person is aggrieved by this particular conduct, that person should be the company itself, but none others. How the company can file a suit? Again by majority decision. So if the majority approves, question of company filing a suit does not arise, then the minority shareholders will have to trigger 241 to 246 under the Companies Act 2013, and then invoke the provisions of oppression and mismanagement, and then go to the National Company Law Tribunal and agitate there, and ultimately they had to subject their grievances to the finality of the NCLT, followed by the NCLAT, and then the Supreme Court thereon. So this is the hierarchy in which we are now going to discuss this particular subject matter. This particular decision of F.C.S versus Arbitrator in serious company cases, it's found. You can trigger it. I think I have already sent you this particular judgment also, and you have received it. It is 1843 matter. The F.C.S and in this case and Turton, two shareholders of the company, brought an action on behalf of themselves and all other shareholders against the directors of the company, and also the solicitor of the company, alleging that in fact that by their concerted and illegal transactions they had caused the company's property to be sold at a loss, and it's a great loss to the company. It was specifically alleged that there was no qualified board of directors, and the shareholders claimed damages to be paid to them by the directors of the company, and it was taken to the court of law. Then friends, it was held that the action is not sustainable because the minority has done it and the majority has already upheld the action of the directors of the company. And in such a case, only the company can bring a proper suit, and the proper party to agitate is the company itself as a plaintiff. And then it is the majority of the shareholders of the company which is competent to decide the matter. And then the reasons stated by Lord Justice Mellish in this particular subject matter are very salutary. And then this was done in Mac Douglas versus Gardiner, 1875, Chancery Division. Well, friends, this is the reasons were further stated by Lord Justice Mellish in Mac Douglas versus Gardiner, 1875, Chancery Division. I just read it coolly, please listen and then take down. Justice says, if the thing complained of is a thing which is in substance the majority of the company are entitled to do, or if something has been done irregularly which the majority of the company are entitled to do regularly, or if something has been done illegally which the majority of the company are entitled to do legally, there can be no use in having litigation, but the ultimate end of End of. The subject is only that a meeting has to be called for, and the ultimate power is vested with the majority, and the majority gets its wishes. So, majority rule is supreme. First versus Horbotel further, in fact, substantiated 1875 in MacDougall versus Gardiner. These are the two most important English cases you are supposed to take down. Now we will come to an English judgment. This is by Supreme Court of India in 1956. This is Rajmandri Electric Supply Company versus Nageshwar Rao. All India Reporter, AIR, 1956, Supreme Court 213. Now the Supreme Court says in this case that the courts will not, in general, intervene at the instance of shareholders in matters of internal administration, and the courts will not interfere with the management of the company by its directors so long as they are acting within the powers conferred on them under Articles of Association of the company. Moreover, if the directors are supported by the majority shareholders in what they do, the minority shareholders can in general do nothing about it. This is the most important judgment in the line of Indian courts. The apex court of the country has decided. I have already driven your attention to the judgments of the English courts. Now, another important English citation. Pavlidis, Pavlides, Pavlidis versus Jensen, Jensen, 1956. A minority shareholder brought an action for damages against 3 directors and against company itself on the ground that they have been neglected in selling a mine owned by the company for 82,000 pounds, whereas its real value was about 10 lakh pounds. Held action not maintainable because only the company by vote of majority can decide, and then these people in fact cannot make this particular exigencies. Then friends, under these circumstances, in fact Pavlidis versus Jensen is a very important judgment, 1956 Chancery Division, page 565. And in this connection, there are a number of English cases which follow, and some of the important judgments happen to be Edwards versus Halliwell, which confirmed this judgment. Then Gray versus Lewis, and then the Bamford versus Bamford, and then there are a number of other English judgments. I would like to deal with these particular judgments in detail further in our next session tomorrow. Let us go coolly on this particular subject matter. Now I have told you the principle. I have told you the English judgments. I have told you the supporting Indian judgments, the Supreme Court of India's judgment. The other supporting English court judgments I am going to tell you in tomorrow's session, followed by the exceptions thereon, and those exceptions also will go on. This particular session would continue for 2 or 3 days. Because from any angle you can get a question. The last part will be oppression and mismanagement, 241 to 246. That is the law. This is the case law. This is how you have to make out a study of the subject matter. This is a very important research topic also. That's the reason why I request you to go through these judgments through CLA, or in internet also they are available. And if time permits, probably I will try to download. Otherwise, you can download yourself. So very well, friends. I thank you very much. We'll meet again, and then we'll go for other part. Now part 1 is over. In part 1, I have told you the principle. I have told you the 3-4 important judgments of the English courts. Then the judgment of Supreme Court of India in Rajahmundry's Electric Supply Company's case versus Nageswara. Then the other judgments which followed subsequently from 1840 later on till now, the most important judgments I will cover. Then I will come to the exception part. Then under exceptions, last part would be the legal provisions under the Companies Act 2013, sections 241 to 246. So this is the menu we are going to have from tomorrow onwards. Thanks for your patient hearing. Thank you very much.